Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. If you find that the state has called two witnesses or the equivalent thereto and proven each of these elements beyond a reasonable doubt, you must find the defendant guilty as charged. If you find that the state has not called two witnesses or the equivalent thereto or failed to prove one or more of these elements beyond a reasonable doubt, you must find him not guilty. The rule of lesser included offenses, which I explained in my charge on the second count, applies to the 14th count as well. If and only if you unanimously acquit the defendant of capital felony as alleged in the 14th count, you must consider the lesser included offense of felony murder. I have already instructed you on the elements of felony murder in my charge on the 10th count, and I need not repeat the instruction. You must keep in mind that, with respect to the 14th count, the state alleges the underlying crime of sexual assault in the first degree rather than the underlying crime of kidnapping. This means that with respect to the lesser included offense of felony murder, the state must prove beyond a reasonable doubt that the defendant committed the crime of sexual assault in the first degree, that the actions of the defendant in the crime of sexual assault in the first degree caused the death of Jennifer Hawk Pettit, that the defendant caused the death of Jennifer Hawk Pettit while in the course of and in furtherance of the commission of the crime of sexual assault in the first degree or in immediate flight from the crime, and that Jennifer Hawk Pettit was not an intentional participant in the crime of sexual assault in the first degree. If you find that the state has proven each of these elements beyond a reasonable doubt, you must find the defendant guilty of the lesser included offense of felony murder. If you find that the state has failed to prove one or more element beyond a reasonable doubt, you must find him not guilty. The 15th count accuses Stephen Hayes of burglary in the third degree and charges that at the town of Cheshire on or about the 23rd day of July 2007 between 3 a.m. and 10 a.m. at 300 Sorghum Mill Drive, the said Stephen Hayes entered or remained unlawfully in a building with the intent to commit a crime therein, to wit, larceny in violation of section 53A 103 of the Connecticut General Statutes. Section 53A-103 of the Connecticut General Statutes provides that a person is guilty of burglary in the third degree when he enters or remains unlawfully in a building with intent to commit a crime therein. For you to find the defendant guilty of this charge, the state must prove each of the following elements beyond a reasonable doubt. 1. That the defendant knowingly and unlawfully entered or remained in a building, and 2. That the defendant unlawfully entered or remained in the building with the intent to commit a crime, namely larceny in the building. The first element that the state must prove beyond a reasonable doubt is that the defendant knowingly and unlawfully entered or remained in a building. Building has its ordinary meaning. It is a structure that may be entered and used by people as a residence or for business or for other purposes involving occupancy by people, whether or not it is actually entered and used as such. A person unlawfully enters or remains in a building when the building at the time is not open to the public and the defendant is not licensed or privileged to do so. To be licensed or privileged, the defendant must either have consent from the person in possession of the building or have some other right to be in the building. The second element that the state must prove beyond a reasonable doubt is that the defendant unlawfully entered or remained in the building with the intent to commit a crime, namely larceny in the building. I have already instructed you on the law of intent in my charge on the first count, and I need not repeat that instruction. I have, in addition, already discussed the elements of larceny in my charge on the 6th count, and I need not repeat that instruction. Even if the defendant never actually committed the crime of larceny in the building, if the evidence establishes that he was there with such intention, it is sufficient to prove that the defendant unlawfully entered or remained in the building with the intent to commit that crime therein. If the state proves each of these elements beyond a reasonable doubt, you must find the defendant guilty as charged. If the state has failed to prove any of these elements beyond a reasonable doubt, you must find him not guilty. The 16th count accuses Stephen Hayes of arson in the first degree and charges that at the town of Cheshire on or about the 23rd day of July 2007 between 3 a.m. and 10 a.m. at 300 Sorghum Mill Drive, the said Stephen Hayes did, with the intent to destroy or damage a building, start a fire, and the building was inhabited or occupied, said conduct being in violation of Section 53A-111A1 of the Connecticut General Statutes. Section 53A-111A1 of the Connecticut General Statutes provides that a person is guilty of arson in the first degree when, with intent to destroy or damage a building, he starts a fire, and the building is inhabited or occupied. For you to find the defendant guilty of this charge, the state must prove each of the following elements beyond a reasonable doubt. 1. That the defendant started a fire. 2. That the defendant specifically intended to destroy or damage a building. And 3. That the building was inhabited or occupied. The first element that the state must prove beyond a reasonable doubt is that the defendant started a fire. To start means to commence. To cause an act to be done is to bring it about. The fire started need not be a tremendous one. The mere striking of a match can be the start of a fire. The fire must be incendiary in origin. It must not be accidental or started by carelessness. In considering whether the fire was incendiary in origin, you may rely upon all the facts and circumstances at the time and place of the fire as you find them to have been proved, and may draw any reasonable or logical inferences from such facts. The mere fact that there was fire damage to a building does not create an inference that its origin was incendiary. The second element that the state must prove beyond a reasonable doubt is that the defendant specifically intended to destroy or damage a building. I have already discussed the law of intent with you in my charge on the first count, and I need not repeat that instruction. Building has its ordinary meaning. It is a structure that may be entered and used by people as a residence or for business or for other purpose involving occupancy by people, whether or not it is actually entered and used as such. The third element that the state must prove beyond a reasonable doubt is that the building was inhabited or occupied. If you find that the state has proven each of these elements beyond a reasonable doubt, you must find the defendant guilty as charged. If you find that the state has failed to prove one or more elements beyond a reasonable doubt, you must find him not guilty. The 17th count accuses Stephen Hayes of assault in the second degree and charges that at the town of Cheshire on or about the 23rd day of July 2007 between 3 a.m. and 10 a.m. at 300 Sorghum Mill Drive, the said Stephen Hayes, with intent to cause physical injury to another person, to wit, William Pettit, did intentionally aid Joshua Komarjewski in causing such injury to William Pettit by means of a dangerous instrument, to wit, a baseball bat, in violation of sections 53A-60A2 and 53A-8 of the Connecticut General Statutes. Section 53A-60A2 of the Connecticut General Statutes provides that a person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove each of the following elements beyond a reasonable doubt. 1. That the defendant specifically intended to cause physical injury to another person, namely William Pettit. 2. That acting with that intent, the defendant aided Joshua Komarjewski in causing such injury. And 3. That Joshua Komarjewski caused that injury by means of a dangerous instrument, namely a baseball bat, and not by means of the discharge of a firearm. We will stop there, get back to this jury charge later. And now let's try some literary material. Ready? Here we go. In Southern California, Huntington Beach in particular, real estate agents are selling a lifestyle, one in which the outdoors plays a vital role. Given that, it's only appropriate that Terry McCarty, an avid outdoorsman, has taken full advantage of all the area has to offer, fusing his career with his passions. As a committed surfer, snowboarder, endurance runner, hiker, and golfer, Terry has created a name for himself as one of the top agents in this coastal marketplace. A hard-working professional with a natural talent for sales and negotiations, Terry knows the many neighborhoods and communities that comprise the Huntington Beach area like the back of his hand. After earning his bachelor's degree in geography at Cal State Long Beach in 1995, Terry spent several months traveling throughout Australia and Asia before settling down in Surf City. He kicked off his sales career working in the liquor distribution industry and followed that with a short-lived career in the telecommunications field. With a 1-year-old daughter and an eye toward the future, Terry was eager to move on to the next stage of his career. In 1998, he took a cue from a close friend who was doing very well as a real estate agent and enrolled in a course to earn his license. Earning my real estate license and leveraging my experience in sales to become a successful agent was one of the best and most important decisions I ever made, Terry noted. I'm always grateful for the fact that my career combines everything I'm passionate about, helping people achieve their dreams, negotiating on their behalf to create rewarding outcomes, and sharing my knowledge and experience with regard to the greater Huntington Beach area, which, in my opinion, is the best place in the world to call home. Terry's passion for helping clients buy and sell property is evident in everything he does, but is proven by the results he delivers year in and year out. With over 650 completed transactions over the course of his 19-year career, he sells one home on average every 10.5 days. In 2016, he closed 45 transactions with over $30 million in sales volume, once again displaying remarkable consistency. Further, Terry has earned First Team's coveted Hall of Fame designation every single year since 2000, even amid the economic downturn of 2007, proving his ability to rise above even the most challenging circumstances. Get back to some jury charge. Looks like we may finish this one up soon. Ready? Here we go. The first element which the state must prove beyond a reasonable doubt is that the defendant specifically intended to cause physical injury to another person, namely William Pettit. I have already instructed you on the law of intent in my charge on the first count, and I need not repeat that instruction. Physical injury means impairment of physical condition or pain. The second element that the state must prove beyond a reasonable doubt is that acting with the intent to cause serious injury to William Pettit, the defendant aided Joshua Komarjewski in causing such injury. You must find that William Pettit was physically injured as a result of the actions of the defendant. I will discuss the requirement of aiding in a moment. The third element that the state must prove beyond a reasonable doubt is that Joshua Komarjewski caused the physical injury by means of a dangerous instrument, namely a baseball bat, and not by means of the discharge of a firearm. A dangerous instrument means any instrument or article which, under the circumstances in which it is used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss of impairment of the function of any bodily organ. The instrument or article need not be inherently dangerous. All that is required is that it was capable of causing death or serious physical injury under the circumstances in which it was used. Any article, even though harmless under normal use, may be found to be a dangerous instrument if under the circumstances of its use it was capable of producing death or serious physical injury. As I have explained in my charge on the second count, a person is criminally liable for a criminal act if he is an accessory in the criminal act of another. Section 53A-8 of the Connecticut General Statutes provides that a person acting with the mental state required for commission of an offense who intentionally aids another person to engage in conduct which constitutes an offense shall be criminally liable for such conduct. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Intentionally aid means to act in any manner, the conscious objective of which is to assist, help, or support. If the defendant intentionally aided Joshua Komajewski in causing physical injury to William Pettit by means of a dangerous instrument, namely a baseball bat, he is guilty of assault in the second degree as though he had directly committed that crime or participated in its commission. To establish the guilt of the defendant as an accessory for assisting in the criminal act of another, the state must prove criminality of intent and community of unlawful purpose. It must be established that he acted with the mental state necessary to commit assault in the second degree, and that in furtherance of that crime he intentionally aided the principal to commit assault in the second degree. Evidence of mere presence as an inactive companion or passive acquiescence, or the doing of innocent acts which in fact aid in the commission of a crime, is insufficient to find the defendant guilty as an accessory. Nevertheless, it is not necessary to prove that the defendant was present or actively participated in the actual commission of the crime of assault in the second degree. If you find that the state has proven each of these elements beyond a reasonable doubt, you must find the defendant guilty as charged. If you find that the state has failed to prove one or more elements beyond a reasonable doubt, you must find him not guilty. When you go into the jury room to deliberate upon the evidence in this case, each of you should ask this question with respect to each count of the information: has the state proven this charge alleged in that count beyond a reasonable doubt? If you find after a consideration of all of the evidence in light of my instructions that the state has met this burden, you must deliver a verdict of guilty on that count. If you find that the state has failed to meet this burden, you must deliver a verdict of not guilty on that count. Your first duty when you go into the jury room will be to select a foreperson. After you have selected a foreperson and received the information and exhibits from the clerk, you will begin your deliberations. We will take the usual lunch break between 1 and 2 p.m. If you wish to take other breaks, such as coffee breaks at other times, you are free to do so. Be sure that the clerk or marshal know the anticipated length of your break. Because the court is unable to pay the court personnel overtime, your deliberations cannot continue past 5 p.m. No one will hurry you to reach a verdict. If you do not have a verdict by 5 p.m. on any given day, you will simply be brought back the next day to resume your deliberations. You are permitted to deliberate only in the jury room when all 12 of you are present. If one or more jurors are not present for any reason, you may not discuss the case. You must wait until all 12 of you are present. This rule is important. If it is violated, we may have to try the case all over again. If you have a question during your deliberation, the foreperson should write the question down on a sheet of paper, sign and date it, and knock on the door. The marshal will then bring the question to me and I will answer it in open court. It may take a few minutes to assemble the staff before you are brought into the courtroom to hear the response. Please try to make any questions very precise. We cannot engage in an informal dialogue, and I will respond only to your written question. If you need to have any testimony or any part of my instructions read back, follow the same procedure. Write on a sheet of paper what it is you want to hear as precisely as you can. For example, if you want to hear only the direct examination or the cross-examination of a particular witness, please say so. Otherwise, we may have to read the whole testimony. Your verdict must be unanimous as to each count. All 12 of you must agree on the verdict. As a check that your verdict is in fact unanimous, the clerk may ask each of you to individually announce your verdict in open court. Each of you has taken an oath to deliver a true verdict according to the evidence. No one must be false to that oath, but you have a duty not only as individuals but also collectively. That is the strength of the jury system. Each of you takes into the jury box and the deliberation room your individual experience and wisdom. Your task is to pool that experience and wisdom. You do that by giving your views and listening to the views of others. There must necessarily be discussion, argument, and give and take within the scope of your oath. That is the way in which a unanimous verdict is reached. When you reach your verdict, knock on the door and inform the marshal or clerk of that fact. Do not tell the court personnel what your verdict is. You will be brought into open court to deliver your verdict. It may take several minutes to assemble the necessary court personnel. You will be asked by the clerk whether you find the defendant guilty or not guilty of the crime charged in the first count of the information. The foreperson will announce your verdict in open court. The clerk will then proceed to the remaining counts of the information. You should not expect me to make any comment on your verdict. It has been my task to rule on issues of evidence and to instruct you on the law. It is your task to decide the case, and I will leave that strictly up to you and make no comment on what you decide. It is, of course, merely the division of duties and not any lack of appreciation of your efforts that keeps me from commenting on your decision. All right, that will conclude our literary and jury charge practice.